Welcome to this week's OK at Work with myself, Sarah Sawyer, and my colleague Russell Berger from the Labor and Employment Group at Offit Kurman. So this week we are talking about arbitration clauses in employment agreements. So sure a lot of folks are familiar with arbitration agreements generally, and a lot of times you'll see them in different contracts, service contracts, employment contracts, and kind of the background is that with an arbitration clause, instead of going and trying a case in court, you try it in arbitration, which is similar but different. It's an arbitrator oversees the proceedings, and a lot of times it can be confidential, and there's people have to pay for it. There's different rules involved. But recently, House Democrats just reintroduced a bill to ban workplace arbitration clauses. Citing that the forcing employees into arbitration is unfair to employees and trying to get rid of those types of clauses. Do you see arbitration clauses often in the employment agreements you work with, Russell, and how are they usually used?
Yeah, I mean, it's certainly a discussion with every client in an employment agreement, whether they want arbitration or whether they want something else. My feeling generally is there is a time and a place for arbitration provisions, but they're not necessarily my default. And a couple reasons for that. One is generally the organizations that run arbitrations require employers to generally pay for employment arbitrations, which means as an employer, you're going to get paid, you're going to pay for the whole thing. In commercial disputes, it could be split by the parties. So it's just going to be a cost. If you go to court, you don't have to pay for the judge. So there's an added cost to employers to arbitrate. Secondly, it's really hard to overturn an arbitrator's decision. It's not, you don't get to just have an appeal of right like you would in court. So you have to show things like bias or some kind of flaw in the process, not in terms of the substantive decision of the arbitrator. So you're kind of stuck with whatever the arbitrator decides. And that can be pretty frustrating if you don't get a good ruling, or, oftentimes arbitrators are inclined to split the baby. And maybe that's not what you're looking for. You're looking for something a little more likely to go one way or the other. So, those are some of the negatives of it. And while, like you mentioned, Sarah, there's positives in terms of confidentiality. Maybe that's not such a big deal with employees as compared to owners of sports leagues have arbitration clauses with each other. So if they get in disputes, it doesn't become public because they don't want their billion-dollar business issues out in the public. Like that makes tons of sense to me. Maybe it's not such a big deal in an employment context. Maybe it is, but that's an individual determination. And the other thing I wanted to mention is where I think arbitration clauses are really useful is you can pair them with what's known as a collective action waiver. So if you have a class of employees where you have a risk of class action litigation, so for example, a certain cohort of employees where you're not sure if you've properly classified them under the FLSA that could sue you and could sue you as a class, the only way to prevent a class litigation is to do so with an arbitration agreement. Because collective action waivers are not valid in litigation. They are, however, valid in arbitration. So there is a way to kind of pair that and reduce class exposure risk.
Yeah, and that's kind of, I think, where sometimes these arbitration clauses come under fire, and they've come under fire in the past before some of these rules that these various arbitration bodies have put into effect. So, back years ago, these often sometimes the fees would be split between the employee and the company, or there wasn't these specific rules always around employment arbitration specifically. And so there was, a lot of big moves around making sure that, arbitrations were fair for employees, especially if they were forced to sign arbitration clauses as part of their employment. So that's kind of where some of these things come into question about, some bills around this and some pushback on that. But it's definitely something that I've definitely used with clients in select circumstances for a lot of the reasons that you've mentioned, is that if it makes sense, whether you do have I mean, some companies do have confidentiality concerns, or definitely when it comes to the class waiver stuff, if you've got a lot of hourly employees, some companies have hundreds of hourly employees and they're pretty sure they're doing things right, but then they find out that they haven't done something right, and that could be a huge exposure risk to a class action. So especially when you've got hourly workers, I think it's something that can make sense from a cost perspective. Even though you're going to have to pay the arbitrator and pay the costs for that arbitration, that could be a lot less than if you had a collective action filed against you and in court instead.
Yeah, well, and to kind of round out some of the options here, it's certainly something that as an employer you should consciously think about and decide what you want to do, because not doing anything at all means you're exposed to jury trials. Even if you don't want to go to arbitration, oftentimes what I think makes a lot of sense is you can have a jury trial waiver, which means you're basically getting trial by judge, which you're not going to have to pay for, which is going to be appealable. But I mean, you're giving up confidentiality, and you're giving up the collective action waiver if you do it in court as opposed to arbitration. But sometimes that jury trial waiver can be, especially if you pair it with a forum selection clause, can be a pretty valuable way to handle this with your employees.
Yeah, and I think it's a good point, Russell, in that section often is towards the bottom of an agreement, right? We've seen them in there, and probably a lot of folks that would watch this would have seen it in an agreement where it says, jurisdiction, venue, choice of law. There's kind of it's kind of towards the bottom with all the standard lawyery, contract terms, right? And so I think a lot of people will go through and just not pay attention to that part and not give conscious thought to these pieces, especially the arbitration piece, or they throw arbitration in there because they've heard that it's a good thing to have, or, oh, I don't want a employee taking me to court, so I'm just going to throw this arbitration clause in there. And so really would caution people not to do that, and that it should be a conscious thought one way or the other, whether it's not there at all or whether you put it in there and what it says. It's not just a throwaway provision in many instances, and actually can make a difference in what happens if things go awry. So definitely something to pay attention to.
For sure.
Yeah. Well, thanks, Russell, and we'll see you next time.
Thanks, Sarah.